billions and billions of dollars in waste, fraud, and abuse. Nobody had any idea it was that bad, that sick, and that corrupt. And it seems hard to believe that judges want to try and stop us from looking for corruption, especially when we found hundreds of millions of dollars worth, much more than that.
We believe that they're going to use the DOGE subcommittee to eviscerate the federal workforce. We think they're going to go after federal departments, agency heads. We think they're going to go after the retirement benefits and use it also to restructure the government.
The bureaucracy is in charge, and then what meaning does democracy actually have? Then we don't live in a democracy, we live in a bureaucracy.
What is wrong right now is one simple reality. What Musk is doing is illegal and unconstitutional.
This is the chainsaw for bureaucracy. Chainsaw!
What is up, everyone? Welcome back to Julio G TV. It's been a while. I hope you all are doing great, and the year has been a great start to you all, this big 2025 year. I think it's going to be a very crucial year. But we're back at it. We've blasted off for the year, and we're bringing you a lot more content this year and even more episodes of the decree, which is what we're doing here today. Today, we got the Big 10, episode 10 of the decree, and we're ready to bring you guys a lot of information. And just to clarify, for those of you that, maybe didn't know what the decree is, or it's been a little bit of time since we brought you one, the decree, remember, is the show where I bring you the latest from a local, national, or global perspective with the focus on the legal aspects, because I'm an attorney and I want to try and bring you guys some of those aspects that really have an impact on what we're seeing. But also, the overall goal is uncovering and bringing you guys the truth. Now, the reason I've made that the mission of the decree is because we're always seeing two views, which is fine. We have two arguments. There's always a great debate. We have one here, left, right, whether you're left center, left middle, whatever it is on the political spectrum, or any other topic that you could analogize that to. We're going to try and bring you the legal aspects on it and try and get you guys closer to the truth. And today, of course, we're going to focus on something that's been huge in the news, huge locally, nationally, even globally. It's had an effect, whether an actual effect or, causing uncertainty or whatever it may be. There's been some sort of talk around it, and it relates to the Trump presidency. As you all have seen, there's been a lot of things that have been signed by executive order. There's been a lot of actions that have been taken by the president. But today we're going to be talking about DOGE, Elon Musk, and how it relates to the Trump presidency. Specifically, I'm going to be bringing you guys, what are the courts saying about DOGE, which is Department of Government Efficiency? What are they saying about Elon Musk? What are they saying about the Trump presidency or the Trump administration for putting these two things into place, whether it's DOGE or Elon? And I'm going to give you guys some insight on whether, DOGE and what Elon is doing is constitutional. What are the courts saying again, So let's go ahead and jump right into it. Now, the way I'm going to break that down for you all is we're going to look at a case which I think does a pretty good job of what the main issues are with DOGE and Elon. And it's a case that was filed in the United States District Court for the District of Columbia, or D.C. The Attorney General for the state of New Mexico, which is my home state, so shout out New Mexico, land of enchantment, led the efforts of this suit against Elon, DOGE, and the Trump administration. Of course, Elon was sued in his official capacity, which is going to be important, as a special government employee, which we'll get into later. And of course, Donald Trump was sued in his capacity as the president. I also want to mention something, that's interesting to keep note of. Shouldn't have much of an effect on how this case is decided, but it's interesting because of what the judge has done so far. The U.S. District Court judge on this case is an appointee under or from Obama or the Obama administration. So just interesting to keep in mind. A lot of these factors play into it. But I just wanted to mention that. There were several other states that joined New Mexico's Attorney General, who is Raul Torres.
My name is Jeff.
I have an opinion on him, as I and several of us watched that election very closely. But I digress. We'll leave that for another day. So there are many other states that joined New Mexico in this lawsuit, including Arizona, California, Hawaii, Massachusetts, Nevada, several others. And of course, everything that I'm referring to here in this video be down in the description so you all can read it yourself. I think it's over 100, 120, 150 pages. But if you read it, you're going to have a very great understanding, or at least know where to look next to try and understand it better of what's really going on and why they're claiming some of the things that they're claiming. So what the Attorney General for New Mexico filed along with these other states is what we call under the law a complaint for declaratory and injunctive relief. So it's two things. The first one is overall they want the court to decide, whether or not this is constitutional. What are the rights? What are the processes? What should they be doing in order for DOGE and Elon to be taking this action? Are they already allowed to be taking this action? They want the court to determine that. Now, I think that this isn't going to be settled at the district court level. I also don't think it's going to be settled at a higher appellate court level. I really think this is an issue that it's going to make its way up to the Supreme Court, whether by emergency or by way of filling it all the way up. We'll just have to wait and see. But I think this lawsuit is a good way to trace it, good way to track it, because it's really making the important arguments, and also we'll also see the important counter arguments in how the court is going to hear it, is going to listen to it. The second thing that the lawsuit is doing is it's asking the court to take quicker action before it decides that overarching issue of constitutionality. And so the second thing it wants it to do immediately is to stop Elon, DOGE, and Trump from doing anything that they're doing or from what they've established with DOGE. And that's mostly what I'll focus on here today, but I'll also give you an insight as to what we could expect the court to do overall. And we'll keep watching it closely, we'll keep updating you on it. But here's the other thing I want to preface is, again, as we've seen with everything in the news and everywhere else, is we're getting two very polarizing views, as unfortunately, we've had a polarized politics very, very much lately. And we kind of see it peek through in this lawsuit filed by New Mexico's Attorney General and some of the other states. In fact, you're going to see the narratives take these sort of political views or political narratives and implement them into this legal action. And so I just want to, give you that preface a little bit, because the complaint starts out by pretty much saying that DOGE, Elon, and Trump are abusing power, unchecked power, that we might have seen or decided to break away from in the 18th century British monarchy. They've gone that far. They're comparing their actions to the British monarchy. Not only that, they're also saying that they are establishing a tyrannical government by what they're doing. And essentially they're saying that our Constitution, which gets them into the constitutional arguments, is what we put our Constitution in place, adopted this Constitution to prevent and break away from the monarchy, to prevent and fight against any tyrannical government. It's what some of our amendments are for. And so they've really taken, in my opinion, a very extreme approach, but I get it. If I was writing that brief on that side, I would do anything and everything to try and make my argument as strong as possible. So it makes sense. Is it true? Probably not. But that's what they're claiming. They're tyrannical. They're a monarchy. This is unconstitutional. And here's why. So essentially, they're making their argument on the constitutionality of Trump, Elon, and DOGE and their actions, or the establishment of DOGE, based upon what we call the Appointments Clause under the Constitution. They say that the Appointments Clause, again, was instituted to protect what they believe here is tyranny, which is, the cruel or oppressive government, unchecked power, unrestrained exercise of power, things of that nature. And so they're saying this Appointments Clause that they're making their argument on was instituted to prevent against that. And they also claiming that this Appointments Clause was instituted to also support what we know as the separation of powers between the three branches of government. And the way it did that is, the Appointments Clause was designed, again, to support the separation of powers between the three branches of government. And what it does is it creates offices or agencies that the president can fill, and it also requires the Senate to confirm a nominee to an office created. For example, we see the Appointments Clause in play when we look at, some of the recent Senate confirmations. For example, RFK Jr. for the Department of Health and Human Services. That would be a perfect example of what we're looking at here, what the Appointments Clause does, what it's for, and what, certain things have to be followed procedurally in order for a appointment, a nominee, an officer to be put into an office constitutionally based upon that Appointments Clause. And so that's the Appointments Clause in a nutshell. Very general, very, very summation of it, but it gives you an idea of the argument they're making. Essentially, also, it's claiming that, and that's when I say the lawsuit is claiming that Elon has limitless and unchecked power based on actions he's engaging in, given that he is unelected and unconfirmed for an office that does not or was not created by Congress. So now you could see how they're trying to put DOGE and Elon into this box that is not under the Appointments Clause. They're pretty much saying, okay, was DOGE established by Congress? Was DOGE an office or agency established by Congress in which the president can nominate and fill under the Appointments Clause? They're saying, no, it was not. That's why it violates that first part. The next part they're going to try and put into the box of Elon and DOGE is, and the administration, of course, given that, DOGE and Elon were put there under the executive office of the president, which is why Trump was brought into the lawsuit, or the Trump administration. The next thing they're going to do is, under the Appointments Clause, it also distinguishes between two types of officers. There's what we know as inferior officers and what we've become known as principal or non-inferior officers. So again, two types of officers, inferior officers or non-inferior officers. The exercise of significant authority associated with officers of the United States includes, here's some of the things that officers can do. Authority to receive, oversee, disperse public funds, authority over contracts, the power to determine the use of and access to government property, and the power to issue regulations, rulemaking and things of that nature. Now, let's take a look at how principal officers get into office, whether they get into that office or agency. Well, again, principal officers must always be nominated by the president and confirmed by the Senate. Inferior officers must be nominated by the president and confirmed by the Senate as well. However, unless Congress creates an exception and by law vests the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. So, in other words, when there's no law addressing the appointment of an inferior officer, the principal officer procedure applies, and only the president can nominate the officer, and the appointment requires the advice and consent, or as we've seen, the confirmation of the Senate. So, principal and inferior officers have to follow this nomination and appointments or confirmation procedure to be able to be confirmed constitutionally under the Appointments Clause, unless Congress has made a caveat that says, the president or someone else could do it. We don't need to get involved in it. So again, to kind of break it down for you guys, Constitution, Appointments Clause, creates offices and agencies, and then it creates officers, whether they're principal or inferior. Now, what the states, the New Mexico Attorney General, along with the other states, have argued is Elon and DOGE don't fit in any one of those. Therefore, Elon and DOGE are unconstitutional and must be stopped, is what they're claiming. Now, the other, and that's what they want the court to decide. They want the court to say that for them. Remember, there's two things they want the court to do. They want the court to do that. Second thing is they want the court to tell Elon and DOGE, hey, you guys need to stop what you're doing until we figure this out. And in order for the court to do that, they need to elaborate on what Elon and DOGE are doing, and they have to meet certain factors. But the big one here is they have to establish some sort of irreparable harm, or I'll just refer to it as harm in general, just to give you guys the concept of what's going on here. Now, the lawsuit has claimed that DOGE has secured access to sensitive material in dozens of federal agencies, whether it's the Treasury, Department of Education, Energy, Defense, whatever it may be. They've claimed that he's had access to all this information. Essentially, they're also claimed that DOGE and Elon have asserted power, again, they're going back to that, of an officer under the U.S. And the Appointments Clause. Essentially, they've said that Elon has unprecedented and seemingly limitless access across the federal government and reports solely to the president, has asserted significant and sweeping authority across a broad swath of federal agencies, and has engaged in a constellation of powers and activities that have been historically associated with an officer of the United States, including powers, again, over spending, disbursements, contracts, government property, regulations, and other agency activities and processes. So, again, overarching claim is Elon is directing Trump, claims Elon has all access despite, some other claims on the other side, which we'll get into. Claims Elon has taken monumental action. It also claims Elon, DOGE, and Trump have harmed the states, where that goes into that second factor, as I was telling you. And, but it states that, what the harm that they conclude on, in other words, they're saying they've harmed the states by doing what they're doing or having access to this material. But it's a lot of the complaint, which is what the court caught on, which is what the Trump administration caught on, which is what Elon, DOGE have caught on to make their arguments, is even though they conclude that there's harm, the reasoning, the premise to reach that conclusion relies on statements that are a possibility of harm, may harm, can harm. There's not anything that would allow them to say or reach that conclusion without some sort of jump. It's a big logical leap, so to speak. And so we're going to see how that plays out. But again, essentially, the states are asking twofold, to restore constitutional order with the Appointments Clause. And that's number 2, stop Elon from issuing orders to any person in the executive branch outside of DOGE and engaging in actions of an officer of the U.S. And his actions, they state, are beyond any power he has and has no legal, and the states claim that they should have no legal effect or they're void, essentially. So, in other words, right now what they want the court to do is stop Elon by issuing what we call under the law a temporary restraining order, as I mentioned. So, again, those are the two arguments. Those are the two things that the states, led by New Mexico Attorney General, want the court to do. Now, as I mentioned earlier, they had to sue Elon, or I guess I shouldn't say they had to, but the way they sued Elon in his official capacity is as a special government employee of the executive. Now, he's also been referred to as a senior advisor to Trump, but he was sued as a special government employee. That's how he's sued in his official capacity. Now, as we recall, DOGE was established and organized by an executive order within the executive office of the president. And so now you might be asking, okay, what is what is a special government employee? Well, an employee of the government is an officer or an employee of the executive of the United States government, is someone who is retained, designated, appointed, or employed to perform with or without compensation for need not to exceed 130 days during any period of 365 days consecutively or in a row. Temporary duties, either on a full-time or part-time or, on or off type basis. So essentially that's what Elon DOGE and the administration are saying. Oh no, he's not an officer. The DOGE isn't an agency under the Constitution or the Appointments Clause. He's not a principal or an inferior officer under the Appointments Clause. We under the executive order, he's a special government employee. So that's what they're arguing generally. Now, the next question might be, okay, Elon is a special government employee. Well, what about DOGE? It was organized by executive order. Shouldn't DOGE be organized under the Appointments Clause, as the states have argued? Well, Congress, which Elon DOGE and Trump administration have argued, has provided that the president may establish what they call a temporary organization for a specific period and projects not to exceed 3 years for the purpose of performing a specific study or other project. So there you have it. Elon, DOGE, and Trump are saying Elon's a special government employee, senior advisor to Trump. DOGE is a temporary organization established not to exceed 3 years. And we've heard this throughout the media, other private journalists, things of that nature, that DOGE is temporary. And so, what's the specific study or project? To cut government waste. We've seen Elon hop on stage last week with big chainsaw saying he's cutting government spending. And so, they've made their argument to fit this box now. And so now you could see what the states are arguing, what Elon, DOGE, and the Trump administration is arguing, and what the states are asking the court to decide overarchingly, which is Elon and DOGE constitutional? Do they fit under our box of the Appointments Clause, or does it fit under the box that Elon, Trump, and DOGE are saying, which is a special government employee or temporary organization under federal law? Now, as I mentioned, just to go a little bit further on the DOGE and Trump administration's argument, again, executive order created DOGE. They're saying, okay, by executive order, we invoke this statute of a temporary organization. And again, temporary organization is defined as an organization established by law or executive order for a specific period not in excess of 3 years for the purpose of performing a specific study or project. Also in the DOGE executive order, President Trump further directed federal agency heads to take all necessary steps, in quotes, in coordination with DOGE administrator and to the maximum extent consistent with law, which I think is a very important statement, because in other words, they're saying, what we've heard in the media, oh, Elon's actually president. Trump's not president. Elon's president. We saw them both in the Oval Office. Elon says jump. Trump says how high. Not the case. And I think we're seeing it here in the executive order. Again, two polarizing narratives we're hearing. Trying to bring you guys back to the middle here and really understand what's going on. And I think it's important in that executive order that they say consistent with law, meaning if there's something that isn't consistent with law, Trump, by his executive order, does not want them to engage in that type of activity, because then it would essentially, even though the court might find this, it might remove them from that temporary organization and might remove Elon as a special government employee. And in fact, or by the actions they're taking, put them in the box in which the states have elaborated on, which is those boxes under the appointments clause. And so now, that's the constitutional argument. Now, will the court say it's constitutional? Elon and DOGE, yeah, what they're saying definitely falls under that federal law, under the executive power. Nothing further here. Or are they going to say, absolutely not? Looks like a duck, quacks like a duck. This is an officer, this is an agency, not promulgated or passed by Congress, not confirmed under the advice and consent of the Senate. Elon and DOGE, stop what you're doing right now. You guys are tyrannical. You guys are just like the 18th century British government. Maybe they say that. We'll see. So we can't answer yes or no whether it's constitutional, but at least we know where the parties are going and where the arguments are headed. Now, there might be some other arguments out there, but I think this lawsuit gives us very on point as to what we could expect going forward. Now, again, as I mentioned, the second point of this is the states want the court to issue a temporary restraining order. In order for them to do that, the state needs to meet certain factors in establishing, including establishing that Elon, DOGE, and Trump actions lead to the likelihood of irreparable harm, or I'll just refer to it as harm in this case. Again, this temporary restraining order will say, hey, you guys stop until we figure out the constitutionality of this issue. Now, did the state, the question is, in order for the court to tell Elon and DOGE to stop, to tell the Trump administration to stop what you're doing, the court needs to find that there is a likelihood of harm. Well, a Obama-appointed judge over in the District of D.C. denied the request to stop Elon, DOGE, and Trump from engaging in what they're engaged in doing due to the fact that the court stated that the states did not establish that they will suffer imminent or irreparable harm, or just for purposes of here, just harm. The court goes on to state that plaintiffs' declarations, in other words, what they've stated throughout the lawsuit and their motion for the temporary restraining order, are replete with attestations that if Musk and DOGE defendants cancel, pause, or significantly reduce federal funding or eliminate federal state contracts, plaintiffs will suffer extreme financial and pragmatic harm. In other words, the court is aware that Elon, DOGE, and Trump's actions have resulted in uncertainty or confusion for the states. But here's the key that the court said, quote unquote, the possibility that Elon, Trump, and DOGE, quote unquote, may or quote unquote might take actions that harm the states is not enough. So, in fact, the court cited other instances in which it has issued a temporary restraining order when harm is likely or has occurred. However, the opposite is true as well. So, in other words, the court is saying, hey, states, you guys are the parties here. You as the parties have to show that it's imminent, it's likely that we're going to suffer harm that can't be repaired. We're going to suffer an injury that, can't be remedied. It's going to happen based upon what DOGE, Elon are doing. Court says, nah, your conclusory statements aren't enough to choose the likelihood of harm. You're going to have to give us a little bit more than that. So as of right now, I'm not going to tell DOGE, Elon, and Trump to stop until you bring me something further, or until this is heard overall, to determine or declare, as I mentioned, what is constitutional and what is not. So, that's what the court said. It said, no, we're not going to do it because you all haven't, established a likelihood of harm. You're just giving us mere possibilities. Again, remember I told you earlier, they're taking that big logical leap. They need to provide some more support, some more reasons, a bigger premise to support that there's going to be a likelihood of harm, just not some vague, widespread possibility. Now, another factor I guess before I get to that, the court and the states making this argument based upon, the likelihood of harm, they referred to the axis, some of the things that Elon, Trump, and DOGE have said they are going to do, but maybe haven't done, really hitting on things on how they could be harmed if these things are done. And that's what the court is saying, as to how it's a possibility and not actually a likelihood of harm. Now, the other thing that the states have put into their lawsuit is, hey, Judge, you need to look at the media. The media is reporting that DOGE has taken or will soon take actions. They said they're going to start laying off people. They're going to start firing them, etc. But the court said, hey, I get it. It's alarming. It's concerning. But these reports cannot substitute for specific facts. In other words, the court is saying that these widespread media reports are not specific facts that we would find in an affidavit. Man, that makes me very happy, because that judge, again, an Obama-appointed judge, just said, I'm not going to take judicial notice of media. I'm going to take notice of what you present to me here in this court by evidence, whether it's by facts that are in an affidavit or otherwise. People swearing under oath, making a statement under penalty of the law that, there's been harm or a likelihood of harm. And the court, went on further to say that, we need specific facts in an affidavit or a verified complaint that clearly show that immediate irreparable injury, loss, or damage will result. The court may take judicial notice of news articles for their existence. In other words, the court's saying, I agree. I know the news and media has been reporting on this. They exist. However, not for the truth of the statements asserted therein. In other words, they're saying they might be true, they might not, but court isn't going to say they're true here today. The only thing I'm going to take as truth is what I've told you that you need to present here in order for me to tell DOGE, Elon, and Trump to stop what they're doing. Lastly, the court states that even if the states have a strong argument that Elon, DOGE, and Trump have violated the Appointments Clause of the Constitution, it does not mean that the court can issue a temporary restraining order. In other words, the judge here thinks, hey, you guys have a stronger argument on the constitutionality. I really think you guys have put together a very interesting, strong, and interesting argument for the Appointments Clause, saying that Trump and DOGE fall under that, but they haven't followed the processes in order to do what they're doing. But even though I think you might have a strong argument there, which I'm not saying here, you might. I think she's actually saying that. I actually think there's an indication that she might lean in that direction. But she's saying, under the law as a judge, I can't give you a temporary restraining order based upon that constitutional argument. I could only give you a temporary restraining order based upon the factors that you need to meet under a temporary restraining order, which the important one here was that likelihood of irreparable harm, which the court says they did not meet. So that's pretty much it in a nutshell, guys, of what this lawsuit has claimed, what was stated, who's stating it. All these states, they're the plaintiffs. They need to prove that they've been harmed, in order to have that temporary restraining order for DOGE, Elon, and Trump to stop as a result of the court ordering it. And, I think the overarching argument and decisions that we're going to see come down the pipeline, which, of course, you could bet on us to bring that to you, is whether or not DOGE and Elon, these actions, what they've done is constitutional. I think there's good arguments on both sides. Of course, I always think that a constitutional argument is usually a bit stronger, but at the same time, they've utilized state statute, not state statute, federal statute, federal law, to make the argument that, DOGE and Elon don't fall under the Appointments Clause of the Constitution. So I think it's going to be very interesting to watch. But here's what I think. Here's my theory. There's been other theories out there. Even if the court sides with the states and says, okay, yeah, Elon's an officer, DOGE is an agency or office, some people have said, oh, well, maybe they'll try and confirm Elon. Maybe they'll try and establish legitimately now that they have control in the House and the Senate and the president can sign off on it. Maybe they will take it through the processes that it needs to go through if the court tells us we need to do that. But I think that might be a little too much work for them to do, especially retroactively, but could be a possibility. But my theory is Trump is utilizing DOGE and Elon and whoever is working for DOGE to identify what they're, of course, these buzzwords that they've been using, fraud, waste, and abuse. And then if the courts eventually shut down DOGE and Elon and say, yeah, you guys are unconstitutional, no more of this, shut it down, you need to go establish that office through Congress, you need to go get Elon appointed and confirmed. I think Trump and his confirmed appointees or principal officers or other officers that are already already have been confirmed by the Senate in those agencies will carry out the actions which may be deemed constitutional if Elon and DOGE do them by the court. But Trump is utilizing Elon and DOGE to identify all this information. Remember, Elon and DOGE are doing this by very technological standpoint, so they're able to do it at a rapid pace, which also makes sense as to why they're saying they're a special employee, temporary organization. So I think Trump administration or whoever's advising them is very smart to say, hey, let's establish this by executive order. We have a good legal basis to do so. Even if it gets shut down, we'll know where the problems are. We know where the issues lie. They're calling it fraud, waste, and abuse. There might be some other things. It might not be that at all. I won't get into my analysis of that. I do have an opinion on it. But for the sake of this video, I think, like I said, they're being very smart to identify it. And then if it gets shut down, then Trump will say, hey, here's the report, guys. Go do it. You guys are appointed. You guys are confirmed. If you guys think that's spot on, you guys think I'm right or wrong, leave a comment down below and we'll have to wait and see. But there you have it, guys. That's the way I see Elon and DOGE and the Trump administration currently, especially with the challenges that are in play. Again, you could find the lawsuit down below. I've linked it with the motion to tell them to stop, a quick response by the government, and then what the judge ruled in telling them, nope, can't tell them to stop. You could find that down below. And of course, we're going to continue to monitor this and see ultimately how the court rules. I think this is going to be a, very historic decision, whether it makes its way, which I honestly hope it does make its way all the way up to the Supreme Court. But it's going to be very historic because I think we're seeing these arguments being made that are very valid and very, there's a basis to do so, And so let's keep watching. We'll keep watching. We appreciate you guys tuning in to another episode of The Decree. As I always like to say, if you keep supporting, D.O.G.E TV will keep growing. If you can, please like and subscribe. It's very easy. Just bam, hit that button. We really appreciate it because we want to keep bringing you these legal aspects to what we're hearing throughout the media. And we want to bring you guys the closest thing to the truth. That's our goal. And so stay vigilant, guys. Stay researching. Try to reach that goal even on your own as well. But we'll continue to help you out. Again, thank you all for watching. We'll catch you on the next one. Peace.